Okay, so I think we're going to start with our second panel for today, which is focused on a pending Supreme Court case, the Oil States Energy versus Greens Energy Group case, which was argued before the court on November 27th, and we're still waiting with eager anticipation for the court's opinion. I thought, since not all of you are necessarily familiar with the case, I'll try to give a kind of a brief introduction to it to sort of save our panelists trying to work that into their initial remarks. The Oil States case is a case involving a patent, which is owned by Oil States, was granted by the PTO after its initial examination for patentability, but was later canceled through one of these post-issuance proceedings generated by the America Invents Act, namely inter partes review. As was remarked earlier, I think by Artie in the prior panel, even before the America Invents Act, we did have some post-issuance proceedings that the PTO could conduct to cancel issued patent claims, namely ex parte reexamination, where third-party challengers would largely drop out after potentially being involved in the process of petitioning for and therefore helping launch the reexamination. And then starting with a new enactment in 1999, inter partes reexamination, where you could have a third-party challenger involved more in the process after its initiation before the PTO. But both of these proceedings, for reasons I won't go into here, were not viewed so much as great substitutes for challenging patents in district courts, where commonly when someone is accused of an infringement, they'll not only argue that they don't infringe the patent, but will commonly also challenge the validity of the patent claims that are asserted against them. Inter partes review, on the other hand, has been, by comparison, wildly popular among third-party challengers. And now we're getting something on the order of 1,000 petitions for inter partes review to the USPTO each year, which is not quite up at the level of the number of patent infringement suits brought in the district courts, but is at least comparable to the few to several thousand patent infringement suits you see brought in the district courts each year. So this is a proceeding that does seem more of a viable substitute in many ways for litigation of the validity of issued patent claims in the district courts. That has, in some ways, helped fuel the current challenge before the Supreme Court, where the court is reviewing a single question presented, which somewhat abbreviated is whether inter partes review violates the Constitution by extinguishing private property rights through a non-Article III forum without a jury. So the idea is here you're substituting for litigation before the district courts, which would commonly involve a jury required by the Seventh Amendment, a review by the PTO, which will then be subject to Article III review, but only at the appellate level. Well, we have a great set of panelists, I think, to discuss such questions, three of whom, Adam Mossoff of George Mason, John Duffy of the University of Virginia, and Sophie Wang of Choate and the Boston Patent Law Association, were involved in the filing of amicus briefs in the Oil States case. And then one of whom, Caleb Nelson, also of the University of Virginia, has written an important historical article. At least I think it's an important historical article. It's been cited by Supreme Court justices previously on administrative and Article III adjudication, largely looking at the 19th century. And he'll, somewhat like Professor Todd Rakoff in the prior panel will help provide a kind of external perspective, or at least a perspective of someone who isn't so much of an expert and embedded in intellectual property law and patent law on what this dispute looks like to him. So with that, I'll turn it over to Adam, who will be our first panelist, providing initial remarks of about 6 minutes or so.
Thank you, John. So underlying, of course, the explicit question presented about the Seventh Amendment to the Supreme Court in the Oil States case, of course, is a primary predicate issue of what is the actual legal status of patents. Are they a public right or a private right? In fact, this was the primary issue that had been disputed within the federal circuit and among scholars up until Oil States, and it was the basis of many of the cert petitions that had preceded Oil States that had been denied. It's the basis of Judge Dyke's decision in MCM Portfolio, where he actually said very definitively that he thought that patents were public rights in the context of the PTAB, and therefore patent owners could not challenge the PTAB as violating their constitutional rights. So this is kind of a predicate issue the Supreme Court is going to have to address as a foundational issue to get to the constitutional issue, because you don't provide the types of constitutional protections for private property rights if they're deemed to be public rights. So they have to kind of resolve this issue. Of course, the Supreme Court, they could punt it. They can do anything they want. They're the Supreme Court. But at the end of the day, it will have to be addressed at some point. Now, at this point, then, I think it's important to recognize that, and I think Professor Rai was exactly right. The modern Supreme Court decisions on this public versus private right distinction are a mess, as modern Supreme Court decisions are in every area of law. And in fact, in all areas of law, you can look to court decisions over 200 years where they talk about legal rights, and you can find court decisions that emphasize the public aspect of legal rights, whether you're talking about contract rights or property rights or rights of liberty, and you can find court decisions that emphasize the private aspect of legal rights, the rights of liberty, rights of contract, and rights of property. In fact, this is a great decision by Chief Justice Taft in 1923 in the Crown Die and Tool Manufacturing decision, where he kind of first goes on for the first half of the opinion talking about how patents, you have the natural common law rights of use, ownership, use, and disposal. This is secured by the patent. The patent only makes these rights exclusive through a right to exclude. So framing it as a private right, and then like halfway through the opinion, he completely shifts, and then for the rest of the opinion, he talks about them as a monopoly privilege grant that restrains commercial actions. So now it's true, like all legal property rights, patents arise from grants of a government institution. Patents arise from the Patent Office, but all property rights in land actually find their root in a patent grant by some government institution. And the Homestead Acts were grants by the government of property. And in fact, like all legal property rights, patents being one of them, all property owners interact with government officials and agencies. And in fact, it's been a long-standing doctrine in the common law, in the area of real estate, that there's this doctrine of property affected with the public interest, which is a real estate doctrine, and in fact, it had a resurgence in the United States law in the turn of the 20th century. And of course, you heard on the last panel, good discussion by Professor Murray and again Professor Rai and others about the police power regulation of real property rights and takings doctrine and things of that sort. So in this respect, I don't think this tension between framing of private versus public that one finds in doctrine in patents is unique to patents. And I don't think patent lawyers should think of it as unique to patents, because one sees it in all areas of property rights. And of course, you can find particular decisions that say it's a public right. You can find particular decisions that say it's a private right. But what is the weight of the legal decision making by both government officials, judges, and even the rights holders themselves as stakeholders in acting upon the rights that have been secured to them? Well, this is my research, historical research. I've read every 19th century patent decision reported in the Federal Cases Reporters, and many, all legislative history and many licenses and assignments in the 19th century. And I can tell you that the primary weight of the authority in practice has been a framing of patents as private property rights, right? So you get lots of references by judges and by lawyers referring, for instance, invention is similar to creating an inchoate private right in land through first possession, which is then perfected by obtaining a patent in the same way that one perfects one's title in land by obtaining the actual title grant from a patent. And they define patents by reference to common law property rights. So patents were identified as a title deed. Patent infringement was very early analogized to trespass. And in fact, they adopted into patent law in the 19th century common law conveyance concepts. So licenses and assignments, which many people think of today as contract doctrines, are in fact common law property doctrines, defining the scope of a property interest that's conveyed to a third party by a property owner. So now I entirely acknowledge and concede it's true. The examination and issuance of a patent is an administrative process. I mean, that's undeniable. And I think Professor Rai is exactly right that you have to distinguish in this respect between examination of the substantive requirements for obtaining a patent versus the patent as issued as a property right. But that's the point. Once it's issued, it's a vested private property right. Now, it's a hybrid private property right of a certain sort, not hybrid in terms of public or private. In the 19th century, it was very often identified as sharing characteristics in private property rights between real estate and chattels. And this has now been confused thanks to the 1952 Patent Act, which codified this jurisprudence and referred them as personal property rights. But nonetheless, the historical treatment of patents, both by courts, government officials, and the owners of patents themselves, confirms that these are private property rights, and courts thus provided protection in the 19th century to patents as private property rights under the Takings Clause, under the Due Process Clause, under the 14th Amendment in modern jurisprudence, and sorry, I'm timing myself, and I think that this is a very important point. Now, this doesn't necessarily decide that they get Seventh Amendment protection for jury trial, but this does say that they do get review and protection under the Constitution as such. So, and that's a significant implication of this division between public and private.
So I'm going to begin where Adam left off and give kind of the counter argument. I think that under my view, and I think this is likely to be where the court is going to go, the court is, I think, likely to say that the patent is a private property right with respect to the rights it grants to against other individuals. But with respect to whether the grant initially is correct or not, that's something that involves the government. It initially involves the government in granting the right, and that very much is a public right. The patentee, if they make a certain invention and they comply with the Patent Act, if they comply with the Patent Act, they have a right to obtain a patent under our statutory law, and that's a wonderful thing. It's not granted just as it's not granted just in the discretion of the government. There's actually rights to get a patent, but still it is a public right. And that's what the Patent Office is re-examining. There's two reasons to think that those rights are re-examinable inside the administrative state. One is that, though Adam talked about the hybrid nature, he was talking about whether they're more like land or more like personal property. The statute, as Adam noted, the Patent Act does say they have the attributes of personal property. Well, if you think about something that's got a little bit like a hybrid between land and interest in land and personal property right, the obvious analogy is a lease. A lease of land is something that is, an interest in real property, but under the common law, and I must say I didn't know this before this case, but under the common law, a lease was considered personal property. That's just true, okay? That's something that is true. And if you ask whether leases could be re-examined administratively, leases from the government, the answer is established by a case in 1963 by the Supreme Court, Bosch versus Udall, which says even though there's some 19th century cases that suggest grants in fee simple cannot be re-examined by a government agency, grants of leases, of governmental leases, are re-examinable by the administrative agency, and that's perfectly permissible, and that's the current law. And that, if you think about a patent, it's a lot like a lease. It's term limited, just like a lease. It's 20 years at most. You have to pay fees during the time of the lease, called maintenance fees, or else your interest goes away. And when the right goes, when the time period is up, it does revert back to the public ownership. The rights granted in the patent go back to the public domain. So I think that if you want to draw an analogy between property rights in land and patents, you would draw it. You could draw it, but it would actually cut in favor of the respondents in this case and the constitutionality of the subject matter. The second thing I'd say is that if you look into the Supreme Court's jurisprudence about so-called public rights jurisprudence, the leading case on this, very old case, is Murray's v. Lessee, which says that the one thing Congress cannot do is it cannot delegate to an administrative agency or the executive branch something that is where the subject of the suit at common law, in equity, or in admiralty. Now, nobody thinks a patent infringement suit is in admiralty. So let's just talk about equity and common law. And if you go back to the early 19th century, one of the things that's interesting there, which is we forget because we live in a post-Blonder tongue world where once you have a patent declared invalid in any one suit, it's invalid for all future suits. But in fact, in the 19th century and most of the 20th century, that wasn't true. And the early 19th century treatise writer, Willard Phillips, who I think is really the greatest treatise writer of the first half of the 19th century on patent law, he said, well, what is the judgment conclusive of in an infringement action? And he said the judgment is conclusive only between the parties to it and only upon the subject matter of the suit. That is the infringement complained of. And then he goes on to explain that's why the question of validity is not binding on subsequent people, because that's not the subject of the suit. The subject of the suit, the private rights at issue, are whether somebody has infringed or walked upon my property, but it does not answer the public question of whether that property is valid in the first place. The last thing I'll say is that if you think about what is really going on in the suit, and indeed why the PTAB was created in the AIA and these stronger provisions for reviewing the validity of patent, it is, I think, a counter-reaction to the growth of the strong presumption of validity, which we're going to talk about a little bit more in the question and answers provision. I don't want to go over my time. But the key thing here to realize is that where we were prior to the enactment of these provisions that allow administrative review was not justified either by old law or by modern administrative law. Under old law, it wasn't justified because the grant of an executive grant of a patent could restrain my individual liberty and impose a burden on me that I cannot overcome without clear and convincing evidence of a restriction on my liberty with no de novo review. Because in the 19th century, there was de novo review of the validity of a patent, no deference to the administrative agency. The evolution of a strong presumption of validity in the late 18th and early 20th century and ultimate codification in 1952 was something that moved a lot of power out of the courts into the executive branch. And here's the kicker. Without traditional judicial review, with no traditional judicial review of the agency's grant. So if the agency granted the patent without really any reasoned decision-making, there was no check on that. So the pre-AIA provision or status quo was not really justifiable under old law, wasn't justifiable under new law, and really what you can see these administrative proceedings is doing is sort of going back to, or sort of a combination of, or applying new law to the, cutting back on executive power, not a diminishment of judicial power, but really a cutting back on executive power, because the executive is now subject to constraints for the first time in the grant of patents, in the sense that they're going to have their decision making reviewed under traditional judicial review standards about whether their upholding of a patent is reasonable, is justified with reasoned decision making. And with that, I'll pass it on to Caleb.
Terrific. Well, Professor Golden charitably described me as an outsider to the field. I think what you can infer from that is that my remarks will not be burdened by excessive knowledge. I do know what I think about the general framework for thinking about these kinds of issues, but I don't really know what a patent is, so it makes it more difficult for me to apply the general framework to the oil states case. With respect to the general framework, so I think it's clear, as everybody agrees, that you don't need judicial involvement when the PTO is thinking about, should I issue this patent? Does this meet the statutory criteria for issuing a patent? That involves what you might think of as the functional equivalent of adjudication. You're figuring out individualized facts, you're applying law to individualized facts, but it's not the sort of individualized adjudication that requires judicial power. The executive branch can do that. But we can't automatically conclude that just because the courts don't need to be involved when the PTO is issuing a patent, that the PTO can then say, oh, we made a mistake, we don't need to get the courts involved to cancel the patent after it is issued. In the 19th century, that sort of issue came up with respect to one of the most important branches of 19th century administrative law, the grant of federal lands. So Congress set up land offices within the executive branch to figure out who met statutory criteria for getting federal lands. There were these individualized determinations by the land office. Yes, you meet the criteria, we're going to issue this land patent to you. You didn't need the courts to be involved when the land office was figuring out whether somebody met the statutory criteria and should be issued a land patent. And there were certain grounds upon which land patents could be canceled after the fact. If the patentee had used fraud to get the land patent, or if there were other problems with the grant, the patent was subject to cancellation. But it wasn't subject to cancellation, and according to a long series of decisions, couldn't be subject to cancellation within the administrative apparatus itself. To cancel the land patent, the government had to go to court, because at that point, the person to whom the land had been issued, the person who had the land patent, was claiming to have, as Adam says, a vested property, right? And administrative actors couldn't authoritatively adjudicate in a way that was adverse to such claims the claim that somebody had a vested property right of this sort. So there were bases for canceling a land patent, but you had to go to court to do it, and the agency, it would be arrogating judicial power, it would be acting in a way inconsistent with the separation of powers for Congress to authorize the agency itself to cancel a land patent without any judicial involvement. You could cast that in terms of Article 3. You could cast that in terms of the Due Process Clause. Maybe this is a deprivation of property without due process of law, where due process there would be understood to mean an exercise of judicial power of the sort that only true courts can exercise. But I think in the 19th century it was fairly clear that as a matter of constitutional law, Congress couldn't set up a system where the land office could itself cancel the patents. A second point is, even though public rights are definitely on one side of a whole lot of cases, that doesn't automatically mean that those cases can be handled within the administrative apparatus without the need for judicial involvement. Think about the standard criminal case. When the United States prosecutes me for my crimes, there's public rights on the prosecution's side, but there's my core private rights to liberty or property on the defendant's side, and nobody thinks that Congress can authorize an administrative agency within the federal government to make authoritative determinations of whether I'm guilty or not and to send me to prison for 20 years. That's not the sort of thing that the executive branch can do on its own. You need judicial involvement to make binding determinations adverse to those kinds of core private rights. And that's true even though there are public rights on the other side, public rights that are pitted against my core private rights. I think the Supreme Court has gotten into some difficulty by talking about public rights cases versus private rights cases. The category of public rights and private rights aren't categories of cases, they're categories of rights or legal interests. And it's perfectly possible, as in the standard criminal case, for there to be public rights on one side and private rights on the other side. It wouldn't make sense to call a criminal case either a public rights case or a private rights case. In some ways it's both, depending on what right you're talking about. And the executive branch can compromise the public rights, but it can't authoritatively adjudicate the core private rights in a way that's adverse to the private defendant's right to stay out of prison. Now, of course, liberty is easier than property with respect to that framework. There aren't complicated vesting questions with respect to life or liberty. There are complicated vesting questions with respect to property. So that gets to the question of what patents are. Are they the kind of property rights that are capable of vesting in the relevant sense, and when do they vest? I think the second question would be easier to answer than the first. If we thought these are core private rights of the sort that are like land or personal property that are capable of vesting, I think they would vest at the time of issuance, and we'd be in the same ballpark as the old 19th century land office cases. Maybe the PTO can't authoritatively cancel the patent. Maybe this inter partes review stuff is unconstitutional. I have about 60% confidence in saying I agree with Adam that patent rights are the sort of rights that are capable of vesting in this sense. To be sure, they are created by statute. In that sense, they're statutory entitlements. Congress didn't have to have a patent system. But the kind of right that is created by a patent seems to me to fit the pattern of the type of property that is capable of vesting. And indeed, it almost needs to fit that property to come within Congress's power to create the patent system in the first place. Congress has the power to secure to authors and inventors for limited times exclusive rights. If Congress were to set up a patent system that involved like government co-ownership of the patent, that might be a problem from the standpoint of Congress's enumerated powers. Maybe Congress has to confer the sort of exclusive rights that we associate with a patent for Congress to have a patent system in the first place. My time is up. I will therefore defer to later things why I don't think the Boshi case is a dispositive case against the challenge to the inter partes review. But with that, Sophie.
So from the perspective of a practitioner in this field, I would say I agree with everything that I've heard thus far, but that our urging for the court and for those who are thinking about this is perhaps not to be as so categorical with where to classify this sort of nebulous area of what we're calling patent rights. So one of the issues that our amicus brief presented, and the issue that I think a lot of people are thinking about this, is it is patents, as you've heard in the earlier panel, involve public and private rights. There's sort of no question that there are public and private pieces of it. So when we talk about patent rights, what are we actually talking about? The patent system is much broader than simply a personal right to exclude others from use of their particular invention. The patent system involves a massive agency, the USPTO. It involves this grant from Congress to allow the promotion of the useful arts and sciences and allow the public to take advantage of the innovations that are being developed. So the idea that you can simply take this massive system of this patent system and categorize it as purely a private property bucket versus a purely public interest is sort of one that we're pushing back a little bit against. I think that the main thing that I would say from all of this is this idea of balance. The Constitution is where we get our patent system from, and that is an idea of balance. It's balancing this exclusive right for a limited time with this idea of promoting the useful arts and sciences and allowing the public to have a right to innovation. The AIA talks about balance. The idea of the inter partes review is that it's not infringing upon the right of private owners to actually bring an infringement action. The inter partes review is limited to a very small subset of challenges. It's only Section 102 and Section 103 of the Patent Act. It doesn't even include all of the other challenges that actually examiners at the Patent Office can consider when they're deciding whether or not to issue the patent in the first place. So we're not talking about issues of Section 112, written description, enablement, et cetera. We're really focused on, were there things in the public sphere that were known that could invalidate your patent because somebody else had come up with it before, or it would have been obvious to somebody else what your invention is. That's what the focus of inter partes review is. That's what the focus of Sections 102 and 103 are about. It's the novelty and obviousness of the invention. So in that respect, it's very limited to the grant of the patent that comes from congressional authority to the Patent Office and through this regulatory scheme. It's not necessarily talking at all about the private interest in this particular right. And one of the things that we, in practice, talk about all the time is obviously all of our clients have patents. They're very interested in maintaining strong patent rights. They're very interested in making sure that their inventions are protected and they can later utilize those rights, either to strike deals or, to protect from other harmful competitors in the market. But that right is really just a pure right to bring a lawsuit. Right? The patent right that you get is a right to exclude by way of a lawsuit. And that lawsuit is what governs whether somebody else infringes upon your patent. You do not have a right, at least from our perspective, you do not necessarily have a right to tell the PTAB what they should do, the patent office, what they should do in terms of issuing your patent in the first instance. You can make your case and they can determine whether under the statute you have the authority to actually get your patent. So there's a little bit of a balance here, which I think is missing from a lot of the discussions, and as we'll get into when we talk about what the justices at the oral argument were interested in, the question of private versus public rights actually did not really come up. I don't know if anybody else was at the argument or have read the transcript, but the issue was not one that the justices focused on. And so this is a question of whether they actually need to resolve this categorically one way or the other in order to deal with this particular statute, the AIA, and this particular provision, the inter partes review process, whether they actually need to go as far as perhaps some amici on either side or the petitioner or respondent are actually arguing for. And the last thing I will say that sort of distinguishes, I think in this case, it's a very specific subset of rights that fall more on the public side, is that this is not taking away any rights for infringement actions, and that's the kind of the most important thing I want to hammer home from a practical perspective. You can have parallel proceedings for patent infringement in a district court where a patent owner is able to assert their right to enforce their patent against any and all infringers. And you can have the same action in the PTAB to determine the validity of that particular patent. So it's not like one is taking the place of the other, and I think that's going to be a key distinction where potentially the Supreme Court will look at, because you're not really infringing upon that private right here when you're deciding whether or not the agency was correct in the first instance in issuing that particular document. And one of the things that, as we talk about the oral argument, I think will be of interest is the petitioner, in fact, conceded at oral argument that, and I think it's all over the amici as well, that the idea of reexamination prior to the AIA and current reexamination procedures are actually fine. Constitutionally, they believe that those are fine and those don't present anything. It's only this addition of this seemingly sort of adversarial proceeding that has caused people to be really questioning whether or not this is constitutional. And I would submit that that particular distinction is not really where we should be looking as to whether the agency actually has the authority to continue deciding whether or not its prior decisions were correct. So I'll leave it at that ahead of time.
Yeah, Sophie mentioned we are planning to turn back to talk about the oral argument, but I know sort of Caleb mentioned he wanted to say something potentially about the lease issue. Maybe Adam wants to jump in on that as well. So I don't know if before we talk about what the justices found of interest to them at the oral argument, where I don't think the lease argument explicitly came up, perhaps we should have a little more interchange on that. So I don't know if, Caleb, do you want to present your thoughts on that?
Sure. So if you look at the Boshi case, which Professor Duffy referred to, the Supreme Court's opinion there is pretty cabined. They're trying to say, well, okay, there can be administrative cancellation of this particular lease, which was a non-competitively issued lease for oil and gas rights on federal land. The agency can say, oh, we shouldn't have issued it to you, we should have issued it to this other person. That's obvious. I think that's bad for my position, but the court was cabining its opinion pretty. It said, okay, we're deciding these facts, we aren't deciding other facts, and indeed they dropped footnotes distinguishing some other facts, like the interest of a mining claimant whose location is perfected. So under federal law at the time, if you went and wanted to mine on federal land, you could locate a mining claim on federal land and you could perfect the claim, and you could then have the right to get the minerals out of the land, and without paying the government, you could just use you could sell the minerals. So it was sort of this giveaway of mineral deposits on federal land. The Supreme Court in Boshi said, that looks more like the kind of property that you can't just cancel once the mining location has been perfected. They have a footnote trying to distinguish that from the leases. I think one of the things that was important to the court in Boshi was that with a lease, the government retains title to the property. And that's, I think, not really true in the patent system. So if you had to say, are invention patents more like the mining location claims or like the leases, I think I would be inclined to say they're more like the mining location claims. They are also takings property, I think, although there's some uncertainty about whether that's true or not. But I think the Supreme Court has talked as if patents, if the government were to condemn a private company's patent and say, okay, from now on, anybody who wants to use this invention has to negotiate with us. We get the royalties. We own the patent now. I think the Supreme Court would say there needs to be just compensation to the previous owner of the patent. If you're condemning the property for public use, it counts as takings property. And I'm not aware of, under the traditional framework, property that counts as takings property, but that could just be retracted by the administrative agency without judicial process.
Is it a lease subject to, I mean, could a government give out a lease and it was completely valid under law and just take it back and give no compensation, even though the person paid for the lease?
So I do think the leasing cases.
There are some significant takings cases involving leases.
Right, so I would think leases actually are subject to the takings clause too.
Yeah, so I do think the Boshi case is bad for me, but I am inclined.
But
yeah. So I'll take that.
But you think patents are takings property, right?
I do think they're takings property, just like I think a lease is takings property. I think if the government said, we're going to give you a lease for 20 years, and you just have to pay us $1 million, you pay the $1 million, and then next year they say, we're going to take it, and it's not, I think that's a taking. I think you get at least your $1 million back, and maybe if the property went up in value, that lease went up in value, you should probably get that too.
Well,
I think.
John,
surely there you would have the right, notwithstanding Boshi, you surely would be able to go to court and say, it's not just the agency saying I only get $3.73. I have a right to judicial process about whether I get my $1 million.
That's correct, and I do think that what I take from Boshi is not that a lease is not property for things like the takings clause, or that it is simply that there are some things that we think of as property that are subject to the takings clause, that are personal property, but still can be reviewed as to whether the government made its initial decision correctly, re-reviewed as an administrative matter.
Now, okay. I like to go to a more fundamental issue, and I will pick up on I think Caleb's excellent conceptual point and also the historical point, because this is a nifty argument that, John, you came up with for your amicus brief that you submitted on behalf of your client in oil states. But the problem with it is, first of all, historically, there is no evidence in the historical case law when they thought of patents as property and analogized it to real estate cases, that they analogized it to leaseholds and not fee simples. It's the exact opposite, in fact. They constantly and consistently analogize them to real estate. In fact, I discussed in my 2007 article that arose out of some of my initial research in historical case law, a case where Justice Story actually invoked at common law a case involving enfeoffment of livery of season to help him understand and adjudicate as determinative precedent for understanding a patent assignment. And so an assignment of the title interest. And what you do see, and in fact, by the patent stakeholders themselves in the 19th century, when you read actually their assignments, is that these are written like conveyance instruments of title deeds. They talk about transfer of the title to all successors, assigns, and interest, things that you don't see when you see people transferring leasehold interests. These were not considered conceptually at the time or even legally at the time as lesser interests. They were viewed as synonymous with and analogized consistently to a fee simple. And in fact, that actually ties into Caleb's point adds further support to his conceptual point that that conceptually it doesn't make sense. You even use the term, well, the patent reverts back at the end of its term. You're using a kind of a property notion, a reversion, right? In fact, property concepts were often invoked in patent cases. The patentability requirements were sometimes referred to as conditions precedent for issuance of in the grant of the patent. But there is no reversion back because it's an invention. The requirement of patent is that it had to be novel. In fact, this was a key legal distinction in the United States about why these were not monopoly grants, that these were actually valid property rights issued to inventors and were not taking away pre-existing rights of contract and property as the original royal letters patent grants were monopoly grants, right? Is that because it was new. And so there is no reversion back because the whole point is that you're expanding the public domain by having this new novel thing. So conceptually and even doctrinally, I think as evidenced by the conceptual understanding of it, it's a cool argument about leaseholds, but I just don't think it holds as evidenced by the historical record.
Okay, so John,
So one thing is the 1952 Act is very interesting because it introduced this concept of personal property rights. That's where it first came in. So in some ways, you could say maybe the 19th century doesn't count so much here because it would be constitutional for Congress to say these are exclusive rights, but they're personal property rights. And the other thing that's interesting, which they did in 1952, the other interesting thing, and I'll end on this, is that the 1952 Act is the first time that Congress gave power to the agency to revoke administratively a right. They did that with interferences. Prior to 1952, if the agency had an interference between an issued patent and an application, they would just issue a second patent if they thought that person was the correct inventor, and they'd leave the other patent out there because they didn't think they had any administrative power to revoke it. So 1952 is the first time they got administrative power, and coincidentally, or maybe not so, that's when they declared it to be personal property rights.
Yeah.
One thing on the 1952 statute, it's true that they did that, but there's also the opportunity for de novo judicial review if new evidence is introduced. So the first time that Congress did anything like the current system is 1980, so it doesn't even go back to 1952.
Even then they had de novo review, so it was later, probably 99.
So the inter partes re-exam?
Inter partes re-exam, I think, was the first time.
1980.
Were they...
82.
I would say ex parte re-exam,
I think ex parte, it was unclear under the statute. I think the Federal Circuit read the statute because it talked about patent applicants being able to go to the Section 145 District Court proceeding. They read that as excluding owners, but I think that could have been
on that issue. I thought
Anyway. All right, well, there's much for the three of you to talk about when you go back to Virginia. And with that, I think we'll turn to Sophie to just talk about what her impressions were of the oral argument in oil states which she attended, and also what might have been suggested perhaps by the Justice's focus on another more technical case, which we haven't talked about so much today, but that was also argued the same day, the SAS case.
So I'll preface everything I say with this is sort of like reading tea leaves when you talk about what the justices were thinking or what they were, what's going to be in their minds. But I think it's interesting to point out sort of the background of some of the cases that have been before the court and the case that they took up on the same day, which is the SAS Institute case versus Mattel. That case dealt with a very procedural point, whether or not the PTAB, the panel of 3 administrative law judges who are looking at the inter partes review, are required in their final written decision to actually discuss all of the claims that have been challenged originally by the petitioner, or whether they only have to discuss, which is the current system, the claims that were actually instituted upon. So for those who don't practice in the inter partes space, if for an IPR, it needs to be instituted in the first instance. So a petitioner can bring a challenge to, in the case of SAS, 10 different claims, and the panel first has to make a decision decision as to whether there's a reasonable likelihood that the petitioner will actually succeed on one of those 10 claims. One is enough. And then the panel will write an institution decision. Sometimes that decision is very, very short, and sometimes that decision is quite lengthy. And then trial is actually deemed to be instituted, and the parties will submit their briefs, and there's an oral hearing, and all this proceeding, depositions happen, et cetera. And then the board finally issues a final written decision, and that's the decision that becomes appealable. The final written decision previously was, and currently, is only on the claims that have been instituted upon. So if you only get 1 out of 10 claims instituted, that's what the final written decision is about. That's what the entire trial and proceeding was about. The SAS case involved a petitioner who was seeking to have the final written decision include analysis of all 10 of those originally challenged claims, so that that decision becomes appealable. And I think this is interesting because, as I believe it was Justice Sotomayor, within 2 minutes of the petitioner's argument, pointed out, this is trying to get around the Quozo decision from 2016, and which I believe the previous panel talked about. And Quozo was a decision where the Supreme Court said that the PTAB's authority, the rulemaking authority, in saying that the institution decision is not appealable, you do not have a right to appeal that decision, that was a valid exercise of their rulemaking authority. And so essentially SAS, and I think by most practitioners, are viewing it as a way of trying to get around Quozo, because essentially if you do talk about all 10 claims, even the 9 that you decided not to institute on in the final written decision, you can appeal that decision and go in front of the Federal Circuit and say, actually, I should have been instituted on those other 9 claims, right? So it's a very procedural question. But the interest for me of why that came up at the same time as oil states is that this is not the first time that, I think it was mentioned earlier, that parties have tried to petition the Supreme Court to look at the constitutionality of the IPR process since the AIA. The MCM decision from the Federal Circuit was actually the most, sort of the largest kind of well-regarded opinion on this subject, because it actually went into historical information, interpretation of the statute, et cetera. The oil states case has no opinion from the Federal Circuit, so there's no actual decision from which they're actually looking to what the Federal Circuit decided one or the other. But the court chose to take it up at this time. They denied cert back in the MCM's case, decided to take it up at this time with SAS about a year or so after the Quozo decision. So it looks like the court is looking at sort of this whole inter partes proceeding and looking at whether or not, on the one hand, there's this constitutional authority, this sort of the power of the PTAB and the power of Congress to actually put forth this proceeding. And then all of these process considerations, which I would describe sort of the SAS Institute to be a process type case. And it all kind of ties into the issues present at this conference, right? The idea of the administrative state and how much authority really the PTO has in making these types of decisions. So with that background, I will say that the argument for oil states, I think, surprised some people in the lack of focus, as I mentioned, on private versus public rights. I would say there's probably 3 major things that came out of it that I think a lot of practitioners were very interested in. There was this idea of judicial review. And that's one where I believe Justice Kagan said that was the saving grace for her for the IPR process. And that's relevant because in the SAS case, it's all about sort of what is the scope of that judicial review and what decisions from the PTO are actually reviewable. So that kind of ties in there. There's also this fundamental issue of fairness, and this is what a lot of amici, some of my clients included, submitted briefs about. And I think this idea of this vested property interest sort of really comes down to is the idea for most patents is that companies these days are investing millions upon millions of dollars in inventions and innovation. And so if they get a patent that's issued upon their invention, they put even more money into it and invest in sort of developing sometimes entire companies based upon their initial investment. And so for a non-Article III court, 10 years down the line to come back and basically yank that patent right away is fundamentally unfair. And that's what Justice Breyer was really focused on at the hearing, this question of whether or not it's really fair to allow this type of system to happen without putting it to an Article III court that's been traditionally given that authority to decide the validity of patents. So that was an issue that came up. And along the fairness, and this sort of gets into some of the problems with procedure and process, the issue of panel packing came up a couple times. It was Chief Justice Roberts who was particularly concerned with this issue. And that's just, it's, as I think the counsel for the government correctly pointed out, it's only happened, I think, 3 times in the last, since the AIA was adopted. But the issue is that if you have an agency who is allowed to change the makeup of the panel that's deciding the validity of a particular patent because they don't like the direction where it's going, that, again, strikes as a fundamentally unfair exercise of agency power, whereas a court would not be doing that, and you wouldn't be able to change the makeup of the jury, for example, when they're deciding your validity question. So, again, it's a question of sort of fairness within the process. And then I would say, in general, there was this sort of discussion, I think, about the replacement and the nature of IPR proceedings and whether or not they're just so similar to trials and adjudicatory proceedings in Article III courts, and whether that should be cause for alarm. And I think, as I said earlier, the comparison there, I think, is not. I think it's a little more blown out of proportion in that aspect, because inter partes re-examination has always been a thing, and the court and the petitioner even acknowledged that would have been acceptable constitutionally. But then there's this question of, again, what really is the difference between the inter partes review proceedings right now and prior examination proceedings at the PTAB that were considered fine? It's really this idea of this panel of judges. So I guess there's 3 judges who are deciding, and Justice Roberts had a not great colloquy where he commented that, I'm sorry, when we say judges, we mean something slightly different, which was perhaps indicating his view on the idea. But it's this idea that you have 3 people now, instead of just an examiner, who are looking at the facts that are presented before them by parties who are adversarial to each other, and then deciding whether or not this patent is valid. And that does seem like sort of a validity case. But there's, again, the fundamental differences, right? We're talking about very limited sort of scope, and the justices address that it's really only on novelty and obviousness, 102 and 103 issues, right? There's no issues of infringement. There are no damages that are awarded in inter partes review. There's no decision that that the one party is in fact liable to another party as a result of the proceedings. It's all about whether or not the prior art, demonstrates that your patent should not have issued in the first place. And those are the types of decisions that examiners are making every single day with submissions of hundreds of references, thousands of references at times, that they're looking at to decide if these patents are being issued. So I would say that from the oral argument, it was very interesting to not have to focus on any of the historical discussions or on sort of the public or private interplay. It was much more, I think, and whether or not the decision will be that way, who knows? It'll, I think all of the practitioners are very nervous about what the court could say. But in general, I think what we're looking at is this question of process versus power. Is the whole system, inter partes review, unconstitutional because Congress does not have the power to give this administrative agency all of these rights to actually adjudicate these proceedings? Or is it that the process itself has some unconstitutional aspects to it? There was a question of due process that was raised both in the oil states case and in the SAS case, and that wasn't before the court on either of these appeals. But that's another consideration, which is are there parts of the IPR process that are unconstitutional or deprive people of their rights, whereas the entire system itself is in fact constitutional because the authority is there? And so those are the types of questions I think we took away from the dual arguments on the same day.
Okay, so we want to reserve some time for question and answer with the audience, but we'll swing through, I guess, the rest of the panel just to sort of react to some of these issues raised by Sophie and perhaps look beyond this case, as Sophie already has suggested, to what other potential issues like due process might lie out there to address in this area. So we'll start with John.
Sure. Out of all of Sophie's comments, I think the one that's the most interesting to me personally is the issue of judicial review, because I think that's intimately tied to the rise of these proceedings. So under lower court law, under federal circuit law, which I think is wrongly decided, but let's assume it's true, there's no APA judicial review of the grant of a patent. Let's assume that Congress overrules that. Let's say that Congress simply said the APA applies to the grant of a patent, that people who are adversely affected and aggrieved by the grant of a patent can seek judicial review, just like every other agency. Okay, so that's step one of this hypothetical, and I think that that's constitutional. Let's assume that step is constitutional. Step two is that the agency gets one of these cases, gets the briefs in from the person seeking judicial review, which is a competitor of the patentee, and they read the briefs. Let's say there's 3 lawyers in the room who read the briefs and say, you know what, there's a substantial likelihood this person will win on judicial review. We are going to seek a remand to the agency. Now, there's administrative law on that, and the standard administrative law is if the agency seeks a remand under Supreme Court and DC Circuit precedent, the court is supposed to grant it, supposed to remand back to the agency. Now back at the agency says, we'll let the other party present arguments as to, why this patent shouldn't grant. Now that might take a statutory change, but each of these steps, I think, is constitutional and is indeed very similar to what we do in all other areas of administrative law. Yet the end result would look like, the proceeding at the agency would look like an AIA-type proceeding. You'd have both parties presenting arguments to the agency about whether this grant of the patent, this previous grant of the patent, was correct or not. And ultimately, then you'd get judicial review by either party whichever party loses that proceeding gets to seek judicial review with some degree of deference to the agency. No step in that is either radical or, I think, unconstitutional. And yet, at the end of the day, we've recreated the AIA-type proceedings, which is why I think it's constitutional, and I think why maybe Justice Kagan could perceptively see that if you think that there is judicial review of this, then the whole thing is actually constitutional and sort of well within what administrative law does.
I will just interject on one issue here, which may present a future problem. Currently, before the Federal Circuit in practice, there are several cases, one of which I'm involved in, that are discussing the issue of standing for those who lose at the PTAB, and whether, in fact, you have a practical right to judicial review at that point, and actually for purposes of, for practitioners, if you lose an IPR and you are not somebody who actually has standing, that is, you don't actually practice, you're not subject to an infringement lawsuit, which is what the AIA intended, that anybody could bring a petition, you may not actually have standing to challenge the adverse decision to you in front of the Federal Circuit. So that's an issue that's being currently litigated before the Federal Circuit. So that might affect some of these things going forward.
And I do think standing is very important here because the system I just described, actually, you think, well, the judicial review happens almost immediately after the agency makes its initial grant decision. Not so. The statute of limitations on APA actions under DC Circuit law is statute 28 U.S.C. 2401, which gives you 6 years from the time the action accrues, which could be 10, 15 years, because to accrue, the action only accrues when you have standing to seek judicial review. So it could be quite late in the patent term before the action accrues, before your right to judicial review accrues.
Okay, so Adam, do you have some further comments?
Just very quickly, I always thought that you'll get 2 different results from this based upon how the court thinks of this case. If they think of this as a patent case, and think of this as procedural corrections to examination, I think that the general tenor of the Supreme Court's approach in patent law the past 10 years would indicate that they would find this to be legitimate and valid. If they think of this as an administrative law separation of powers case, I think that they will find it highly problematic. And I think the general tenor of the discussion, as I think Sophie's remarks were exactly right, that they were talking about this entirely almost as a patent case, that this is just about patent examination and whether they got the examination right and whether this is fair or not. Frankly, I think Breyer was playing more devil's advocate when he was talking about these issues. because I think there are significant differences between the PTAB as structured as an so-called Article I court and other types of Article I courts, like the Court of Federal Claims and the ITC and others, where you have greater protections procedurally and substantive of the respective rights of the people. You don't have serial filings of complaints at the Court of Federal Claims. You don't have extortion happening for the basis of filing complaints at the Court of Federal Claims. You have standing requirements. There are tons of Article III type protections that you get. And so if they think of this more from that perspective, they may think AIA was a bridge too far, but I thought the oral argument indicated they didn't think that. So I agree with Sophie on that.
Taylor?
I'll just say a couple words about John's very creative and interesting APA analogy. I guess, to me, normally when an agency confesses error and asks for a court to remand something back to it, the agency is saying, we have taken too aggressive a position with respect to the public rights. We would like to fix something that we did with respect to our statement of public rights. I'm not aware of cases where when the agency has created a private property right, the agency can then say, oh, remand that back to us. We would like to cancel that private property right that may have vested under pre-existing law. I'm not sure that's the sort of thing that agencies get to do. And I guess the testing case is, could Congress have set up such a system for the 19th century land offices? The land office regrets having issued the land patent to me. 10 years later, it seeks a remand to have an adjudication within the land office of whether it should have issued the land patent to me in the first place. I guess I think the 19th century doctrine would suggest that can happen, but it has to happen in a court. Now there is, of course, 20th century case law about the so-called adjunct theory, where the agency can play some role even under the broader umbrella of judicial proceedings. So even if you say patents are core property rights once they've issued, and there does need to be judicial process, cases like Kroll against Benson say, fine, but what looks like an agency decision maker can be given some role in fact-finding within the umbrella of the court. It's kind of an odd concept that an executive agency would be an adjunct to the judiciary. To me, that's sort of mixing things in a way that's awkward, but it happens in Kroll against Benson. Maybe that's where the judicial review idea, Justice Kagan's judicial review idea, is coming in. To the extent judicial review is really important to the constitutionality of the system, maybe it's because we're thinking of the PTAB as an adjunct to the courts, and it's really all happening within the federal circuit, and the PTAB is just an adjunct to the federal circuit. But if you're trying to cast the relevance of judicial review, if you're trying to fit that into the framework that the court has used for these kinds of cases in the past, maybe it's the adjunct theory that's doing that.
Okay. 30 seconds.
One small point is just that if you just granted judicial review and the agency defends the grant of the property right, and ultimately the court overturns the agency, then there is a judicial judgment, and you would agree that that could result in the cancellation or the invalidation of the right. So then the question just becomes, if the agency comes to its lawyers and says, well, we've got this case challenging it, can you brief this? And they say, no, we're going to lose this case. Do you have to have an exception to the standard view that they can come to the court and say, look, we need a remand because we think we're going to lose this? Or does the court then say, no, in this special case, not all others would grant you a remand, but in this case, we can't do that. You have to come in and fight with the other side, even though you don't think you can. And you have to do that before there's any kind of remand.
The problem here is there are two other sides. So the agency is worried that it's going to lose to A. A is saying you shouldn't have issued the patent in the first place. The patent is invalid. The agency says, maybe you're right. We shouldn't have issued the patent in the first place. We don't want to fight with A. But does the agency have conclusive authority with respect to B, the party to whom the patent was issued? The fact that the agency doesn't want to fight with A, maybe it can sacrifice the public rights with respect to A, but I don't know why it's in charge of B's right after B's right has vested.
So I think the key thing is conclusive. Conclusive. It will not have conclusive power because ultimately the court will come back and there will be judicial review.
And that's
Okay, so I do want to see. We'll see. We obviously can continue this till the time when Patrick said we couldn't continue, which is 12:45. But I did want to open up in case members of the audience, have comments or questions that they want to share. So, does anybody I guess you need to come up to the microphone again.
This is why Virginia is such a lively place.
So for Caleb and Adam, I wanted to understand from you what you think Congress could or could not do statutorily. So what did they do in 1952 by saying that this is personal property subject to the terms and conditions of this title? So it's not just personal property, it's subject to the terms and conditions of this title. Was that inappropriate in some way? How does that change the valence of your arguments?
Cal?
So I guess the way this goes to my basic problem of not really knowing what patents are. But the way I'm thinking about it, Congress's creation of these legal entitlements or legal interests can trigger some constitutional consequences if the legal interests fit a certain template, right? So if they fit the template that I think of as core property, traditional forms of property, then Congress can't say, well, subject to the provisions of this title, we get to have an administrative agency take them away, right? We can't use the provisions of this title can't include procedural provisions that are inconsistent with the kind of legal interest that they're creating. But of course, they typically are in charge of what kinds of legal entitlements they're creating, right? The substance of the legal interest. There is a potential problem with respect to patents, just because the nature of Congress's power to create patents does talk about exclusive rights for limited times. There's an old 19th century case, James against Campbell, suggesting that it would be unconstitutional. It's not within Congress's power for Congress to have a system where, like, the government would be able to use the patented invention or the government would be a co-owner of the patented invention, right? That wouldn't be exclusive rights in the relevant sense. So the government couldn't necessarily structure the legal entitlements in certain ways just because of this exclusive rights idea. But if the legal interests that the government creates are either personal or real property in kind of the traditional sense, then I'm inclined to think they can't have the agency having authoritative power to say, we made a mistake, that we shouldn't have issued the patent in the first place. That can happen, but it has to happen in a court. Of course, there's hard questions with respect to the adjunct theory. What role can Congress give the agency within the umbrella of the judicial proceeding? Kroll against Benson has always seemed kind of artificial to me with respect to thinking of the deputy commissioner as part of the federal district court, and therefore I don't really know how far that theory goes. But to me, that's the kind of framework that I would be using, I think, to think about that.
And I think that's an excellent framework for me to drill down into the patent law issues. Might be one of the only people who actually went and read the legislative history to that section, because I got very interested in it, being a property person in patent law, and discussed it at length in an article I published about 5 or 6 years ago called Exclusion and Exclusive Use in Patent Law. And it was very interesting because there was the legislative record of the 1952 Patent Act is very thin anyway, so there's very little in there. But one of the witnesses that was testifying in a hearing concerning that provision actually raised this explicit point to the legislatures, that patents historically have shared both characteristics of both real estate and personal property, and we do not understand that in enacting this provision, you are saying that the decisions that have held it to be characteristics of real property are being overruled or abrogated in any way, because those are significant, because they related to things like the free ability of conveyance interests and things of that sort. And there was a little exchange where it was, yes, we're not intending to overturn this doctrine. So I'm not entirely. They don't explain why they still went with personal property as opposed to just saying patents are property. So it has created, I think, some unnecessary confusion given kind of the shared characteristics. I don't think you can read too much into subject to conditions. That's a restatement of like I said, the longstanding reference to patentability requirements as conditions precedent for the issuance of the title. And moreover, I think it's also referencing other things. So, for instance, this is the first time that Congress codified the what was up to then common law, the extensive common law that patents were property. And they didn't want people then to say, well, you said they were property, ergo they're not, personal property or real property, that's not time limited. So they're saying there's other provisions that define the scope of this right that also define the nature of the property interest that's being secured or granted by the issuance of the patent. But even if you say, okay, it's subject to conditions, which means the patentability requirements as conditions precedent for the issuance of the patent, that doesn't necessarily, and I think this is Caleb's point, authorize the creation of a PTAB-like agency at the Patent Office that can then substantively review the vested patent right once it's been issued. Because it's entirely consistent with the broader framework of the jurisprudence that existed that said, no, once it issues, it has to be reviewed by a court, and it will be reviewed as a property right with the conditions precedent, like we review other property rights of courts. In fact, I think, the Homestead Act...
Adam, I think I just want to gather the remaining two comments.
Fine, yeah.
We might not have time for the panel to respond to these,
Okay.
but it would be great to get the
Sorry.
comments.
Sorry about that.
It's okay. It's fine.
First, an observation, then a quick question, and then a longer one. Mining came up, and I had the impression from reading a long time ago that there were patented mining claims and unpatented mining claims. And patented mining claims are owned, whereas unpatented mining claims are leased. I'm not sure of that. I'm not a lawyer. But that's what I remember reading years ago. Next one, does this decision in oil states have implication for PGR? Because there you can bring in 101 and 112. And the last question has to do with actually what you're challenging. And you're not really challenging title, you're challenging the claims, which are the metes and the bounds of the area that has been set off. And in that case, you're getting sort of tangled, because there is actually either a real owner who actually owns that, or it's owned by the public, 102 or 103. And this begins to sound like a very old issue in law, which I guess is now obsolete, where you don't really know who owns it, and you do, I think, a writ of ejectment so that you can create fictitious people who have standing to bring an Article 3 claim. Wouldn't that be a better way to handle, a writ of ejectment, patent claim ejectment, than this IPR stuff or PGR stuff, which seems to cause all sorts of conflicts with regard to who has review authority, collateral estoppel, and many other issues?
All right. As I said, I think we'll just collect that. We can have our ejectment panel maybe in a future conference. And James, yeah.
Yes, a quick observation about something Professor Golden mentioned, and then a question which follows from that for primarily Professor Mossoff. So the observation was this, that altogether the IPRs, the matters filed, including IPRs and perhaps PGRs, amount to not quite the total amount of patent actions filed in the district courts at the same time. The interesting thing about that fact that's not so apparent, I think, is that there are 80-plus district courts, and there's only one PTAB, which speaks to the enormity of the uptake in these proceedings and the enormity of the administrative challenge in moving the matters through the tribunal, whether they are there correctly or not. The question for Professor Mossoff is this: okay, let's say the Supreme Court says this was wrong, and the proceedings go away.
What happens?
What does your contingency planning look like?
So since this is specifically directed to Adam, I'll give you a minute?
Well, okay.
Take notes.
Yeah, if I was the philosopher king, so this is the big question, right? What will happen? You could have asked this. I think similar questions came up when the Supreme Court said the bankruptcy code the bankruptcy courts were unconstitutional, and everyone said, well, oh my God. The Supreme Court, you have lots of different options, right? They can say this is just on a going forward basis, prospectively, given the reliance interests upon the decisions. They could reinstate all the patents. I don't know. I don't. It's a complicated issue, and it raises lots of complicated questions about what do you do with respect to, I think as of last March, I think it was something like 17 or 18,000 patent claims that have been canceled by the PTAB since they've been created. But that shouldn't change the constitutional question, right? I mean, that's a prudential question. That's a pragmatic question of implementation, but that's not, I don't think, a question of whether the Constitution itself, in the issues about separation of powers and the protection of vested property rights should be decided on.
All right. So with that, I think we'll break for lunch. There's obviously much more we can talk about then. Okay. So thank you, and thanks to the panel.